Ready to learn about the basics of wills? Hey there, my name is Kenner French. I'm with vastsolutionsgroup.com. We just had a client last week who asked us a series of questions about wills. What is a will? Do I need a will? Well, the list goes on. And basically, we're putting together this podcast that's offered by vastsolutionsgroup.com to provide a basic understanding, really, for the entrepreneur as to what is a will. Some people are now getting, let's say, to the age where they're starting to think about and contemplate their demise. And, well, one way of thinking it and getting moves in line for such a eventuality, well, we're probably all going to die one day, right, is to talk about wills. Everyone with property or children should really have a will at a basic element. I mean, there's trust, there's a whole bunch of specifics over and above a will, but it is especially important if you have children, since a will can provide instruction of your wishes regarding who will take care of your children. Now, I should also add, vastsolutionsgroup.com, most of our clients are relatively high net worth on average. Our clients are worth, our active clients are worth $19 million. So they probably need a little bit more trust work, a little bit more sophisticated planning, what we call the moat, money moat. But what I would say is at least have a will. If nothing else, you should have a will. Have it in place so it's a beginning and a foundational element for maybe someone who's a little bit younger who needs to get the process started. A will must meet several requirements in order to be considered, quote, legally valid. Let's go over just some of those requirements. Number one, there must be what's called testamentary intent. This is a fancy way of saying that, well, the will was created with the intention of acting as a will, and this fact is understood by the testator, number one. Number two, the testator is required to have a testamentary capacity at the time of signing such a document called the will. That means the extent and the nature of the property in the will must be understood by all parties. The distribution of the property must also be understood. So it must be outlined in such a way that it really makes perfect sense. Number three, the will must be executed freely. This means the person doing the will cannot be under undue influence of any way, duress or fraud. There must be a reason that they're doing it based on their own thought process. That's number three. Number four. Well, let's say you have a will and it's unsigned. What then? Is it executed? Well, the answer is, drum roll please, the answer is no. It's got to be signed, depending on the state specifically. This may include a notary or a witness. It really depends on the circumstances, but usually, for 9 times that, or I'd say 70% of the time, it's got to have a notary that is there to witness it. Just with estate planning in general, wills also have their own terminology that the average person really isn't exposed to on a regular basis. Why would you? Especially if you're, if you're working in a grocery store, or if you're a contractor. You might not be working with wills and estate planning processes very often, so they get a little complex. But really, if you know a little bit about some of the terms and kind of makes sense to you, it's not as quite of a daunting task to learn about wills and kind of the overall estate planning or the process surrounding one's potential demise. And as General George Patton said, I remember, a good plan violently executed now is better than a perfect plan next week. Why don't we go ahead and talk about some of the legal terms so it kind of all makes sense as far as wills. Testator is the person that died and had a will. The executor, sorry about that. This is the person named by the testator to execute the terms of the will. Okay, this would include distributing the assets and dealing with any debts of the estate. Guardian. This is the person who is designed in the will, or I could even say designated, which is the right terminology, in the will, or appointed by a judge to care for an adult with special needs or to care for minor children. In many cases, the executor and the guardian are the same individual, but not always, but usually that is the case. While a will is a powerful tool for distributing your assets and avoiding probate with certain assets, there are things that cannot be accomplished with a will. Now, what are some of the things that a will not do? That's important to note. You cannot disinherit your spouse. Yeah, that'd be funny, right? Spouses are protected under a variety of laws in pretty much every state. Distribute property that is in a living trust. Can't do that. Can't change the beneficiary of a life insurance policy. You can't leave an excess amount to a charity when there are surviving children or a spouse, meaning the government wants you to take care of your dependents first, typically. You can't avoid probate. While certain assets are excluded from probate, others are not. And can't transfer property that is owned in what's called joint tenancy or with another party. Now, while it's possible to prepare a will without the services of an attorney, it's pretty advisable to use the services of an attorney. In many cases, a will is just all the estate planning that individual needs. It depends on the circumstances, but usually with high net worth individuals, depending on the circumstances, they do need an attorney. There are online services, by the way, that you can use to create a will. Just be certain that you're meeting all the requirements that I mentioned earlier, but also for the state and also for your specific circumstance. Now, your situation can be very simple. You could do it you could do a will for free, in effect. But at the same time, if your circumstances requires the review of an attorney, if there's beneficiaries, if there's any kind of exotic assets, if there's maybe illiquid assets, if there's kind of anything that's above the norm, you really should be meeting with an attorney. We have an attorney. VastSolutionsGroup.com does not do legal work. We have affiliated entities that we're affiliated with that we can provide referrals to those groups that can help you, and they're in line with our consultation and what have you. Now, once again, this is Kenner French. If you have any questions, feel free to give us a call. We all know enough about this, getting this process going. We could refer you to the correct attorney within our affiliate group. Call us at 888-808-8278 or check us out on the web, which is www.vastsolutionsgroup.com. Once again, Kenner French, I appreciate it.